keynote and the panelists so that we guarantee the smooth course of the session. As you know, we have been producing a lot of outcomes over the past years, not only sessions, but also recommendations on terms of service and human rights that are in the annex of this book, which is our annual outcome, the official outcome of the DCPR. We had felt the need for a book to start a conversation, a multi-stakeholder debate. By the way, there are still some copies of the book around, so if you want to grab one, feel free until they do not finish. The main idea of doing this volume on platform regulations is a very obvious but not so explicit observation that many of us have been doing over the past years, working on it as academics or as practitioners. That is that platforms are undertaking a role of private regulators, private police of cyberspace. Differently from the ordinary regulators and police, they are not bound by geographical limits, frontiers, but they are only bound by the architecture of their platform, which is the cyber limit of their cyber land. And on this cyber land, they have quasi-regulatory, quasi-judicial, and quasi-executive powers. They have quasi-regulatory power because they unilaterally define the rules that will have to be respected by all the users, and users have only the possibility to take it or leave it, being standard contract. Users are all adhering parties that can only respect the rules, and the rules will be implemented both in the architecture of the platform to define what behaviors could be undertaken by users, and also algorithmically implemented, which in this part is even more opaque than the terms of service. And obviously, the platforms and many intermediaries, in a more general perspective, do not need public execution of their rules. They can algorithmically implement them, and they can implement automatically also the decision they can take based on the terms of service. For instance, to evaluate when a content is abusive, when something is fake news, that can be done by the platform itself with no precise criteria as what these vague terms really mean. And this is all the policy debate that has been going on over the past year. So we have a lot of material here for an excellent discussion. I would like to give the floor to 1 second to Nico to introduce a little bit the work that we have done, and then we can start with the keynotes.
Yes, thank you, Luca. So I just wanted to briefly mention the connection between intermediate liability and platform responsibility. So in our chapter for this book, we touched upon 3 issues which I think exemplify the role of platforms as regulators, which is being basically produced as a consequence of the liability rules that are imposed on these platforms. So the consequence is that platforms have some duties of care that are not very clearly defined under the law. And our 3 examples that we pose in this chapter are the case of injunctions against, in particular, non-party intermediaries. So intermediaries that have nothing to do with content, but somehow are involved in the transmission of that content. And they are sometimes imposed obligation of result. So they will have to effectively prevent access to, for example, copyright infringing material. But they will have to implement measures which also, in a way, preserve the user rights and freedom of expression among those. And the cost of taking these measures in a granular way so that they can balance, on the one hand, copyright interests, on the other hand, the interests of society more generally and the users in the particular case, fall on them. So, of course, there is this incentive that platforms have to minimize their costs and take measures that are basically as blunt as possible. And we see this problem increasingly with automated enforcement mechanisms. So this is one example. We have a second example of basically delegation of public functions to platforms in the case of the right to be forgotten. So you know you have this basically obligation on search engines following the Google Spain decision to delist material, to delist links to content that is inappropriate or no longer relevant according to the rules of the data protection regulation. So in this case, the court did not impose very clear safeguards for freedom of expression, and so the platforms are, encouraged to be regulators in a way, defining what content should stay up, and the incentive is not clearly aligned with users' interests in this case. And then the third example is with regard to hate speech. So we have this code of conduct that companies in the IT sector signed with the European Commission. It's an agreement whereby they will have to quickly react to notifications of possibly illegal content under the prevention of racism, xenophobia, and hate speech. And the terms of this agreement are quite vague. So the problem is that these platforms generally do not specify what content is illegal in great detail, or in any case, they are encouraged to define their own illegality in their own terms of service. And this might be different from what we have, under the standards of international law. So this is another case where you have platforms acting as regulators as a consequence of some liability obligation imposed by the law. So with that, I think I want to leave to the very dense discussion that we have today, the possibility for other speakers to comment and bring up other examples of this regulation by private delegation of power. And before that, we'll have two very interesting keynotes by David Kay, who is UN Special Rapporteur for Freedom of Opinion and Expression. And then we have Julia Reda from the European Parliament, who has been heavily engaged in the discussion of online platforms in the past couple of years at least. So with that, I leave the floor to David.
Great. Thank you. Luca and Nicola, I think, have really pulled together an amazing volume here. And actually, I think many of the writers are sitting right here looking at me. So I feel like we should be switched around, and you should be here telling us what to think about these issues. I only wanted to make a couple of very brief remarks, and so I'll try to put them in the context of what I think is a remarkable moment, really. So those of you who've been working in this space for many years, and I know you know this as academics in particular, you work in this space that it can be very lonely, right? You're working in the stacks of the library, at least, I'm old enough to know what the stacks of a library are. Now we're Googling or using different databases, and we're doing our research, and we're publishing our work. And it doesn't always involve the kind of interactions that we have in forums like this. But what I think is really interesting at this moment is the work that is encapsulated in this volume is, in many ways, the public policy issue of the day. I mean, it's not just an issue of how do the platforms regulate particular content, or what are their particular modes of protecting privacy, how do they exactly protect fundamental rights, and so forth. That's not exactly what this volume is about anymore in many ways, right? It's also about the way platform regulation has become perceived as an issue of democratic governance around the world. And I think that this is especially evident in Europe, where European regulators are looking at what the platforms are doing in a way that I think that regulators and policymakers around the world are not doing, right? So most places around the world are, to use a non-technical term, freaking out over the dominance of particular companies in social media and search in particular. But they're not doing that much regulation apart from, particularly in repressive societies, just demanding takedowns. Europe is actually taking steps, for better or worse, that are deeply involved in regulating or starting the process of regulating this space. They're starting to look at, well, what are the platforms actually doing? And they're doing it in a context, I think, where there's a sense that control over public space, which many people see the platforms as controlling, the control over that public space has been essentially outsourced, inadvertently, if you can inadvertently outsource, to private actors. And so I think it's just natural for places that are used to regulating to regulate. And they're doing it in this space. And we already heard some of those spaces, whether it's in the context of the Code of Conduct or the context of the Copyright Directive or the context of a new effort on approaching disinformation and propaganda. And I think that this is and I'll just close here, this is just an extremely important moment to have a volume like this. Because, and hopefully policymakers will actually use this volume, or at least their staffers will take your research and boil them down to a few bullet points. Because there's really important material here that should frame, I think, for regulators and for policymakers, how they think about the platforms, the risks that regulation entails, and also for the platforms themselves, what they could be doing more, both as a defensive move in the face of regulation, which, I mean, generally speaking, my view is regulation tends towards over-regulation, and I think that the private companies are going to need to deal with that. But also a guide to users to think about what it is that they're using when they're online, the nature of that space, which is a very fundamental question about how we consider online space as public or not public, and also to engage the public more generally in thinking about these kinds of questions. So congratulations to all of you for producing this volume. Maybe it'll be my winter reading. But it's really fantastic that you've done this at an essential moment, I think. Thank you.
Thank you very much, David. And now Julia.
Thank you very much. First of all, Luca and Nicolo, for allowing me to participate in this really excellent volume that I think is very timely at this moment. And David has highlighted the very intense discussion on platform regulation that we're having in the EU at the moment. And I'm really in the middle of that discussion, dealing particularly with the question of content removal. On the one hand, there has been the communication from the European Commission on tackling illegal content online, which should really be called removing or preventing illegal content online, because this is what this communication is about, in which the European Commission strongly encourages platforms to use automated content removal technologies. And at the same time, we have the Copyright Directive, where it is proposed to actually make these content removal tools mandatory on quite a large number of platforms acting on the internet. And what I perceive in this debate around platform regulation is a great irony that on the one hand, increasingly the kind of honeymoon period of online platforms is over. We have seen some of the negative effects that the platform's power can have on our democracy. And more people and politicians especially are viewing algorithms that are employed by platforms as scary. They are intransparent. They put us into different boxes that we don't really feel we fit into. This is one of the main reasons why there is a strong call for platform regulation, especially in the EU, because there is a perception that the platforms have become too smart and that they do not just act as neutral hosts or conveyors of information anymore. The irony is, however, that the kind of regulation that is proposed, which is internet filters, online content recognition technologies, are exactly exacerbating those problems. They give more power to algorithms because at the end of the day, this is what filters are. They are intransparent, so there will be more intransparent decisions made by those platforms based on algorithms, more discrimination, and at the end of the day, more power will be given to the platforms to change the rules under which we communicate on the internet by encoding them into algorithms. So in a way, we are treating a problem that we're perceived with a medicine that is exactly more of the same thing. And I would really like to discuss this great irony that in a way, we are very uneasy about the power that algorithms have about our individual lives. And I think we've also seen with the data protection regulation that in Europe there is really a need and a demand from the public to have decisions made about them by humans and not by algorithms. And that at the same time, in the kinds of tangible proposals on platform regulation that we have, there is a strong emphasis on having more decisions made by algorithms. So just one example of this phenomenon, in the copyright proposal where copyright infringing material is supposed to be deleted by algorithms, there is a slight problem, and that is the copyright exceptions. From a technological point of view, copyright exceptions are anomalies because it's relatively easy to distinguish, well, relatively easy, between a particular copyrighted material. You can compare it to the material that is uploaded and you can recognize it. But the question whether or not a copyright exception is applied, whether the thing that you're looking at is a parody, whether it's a legal quotation, whether it's used for educational purposes, is an extremely difficult distinction for an algorithm to make. So generally, they simply do not interpret the copyright exceptions. They treat it as an anomaly that is not possible for the algorithm to detect. And if there are no sanctions for removing too much material, but there are sanctions for removing too little material, the platforms are invariably going to err on the side of caution. The problem with that is that the copyright exceptions are not just a technical or legal anomaly, they are also the embodiment of fundamental rights in copyright law. They are there in order to protect competing interests such as the fundamental right to education, the access to information, and the freedom of expression. So if we delegate decision-making to private companies who are either legally obliged or strongly encouraged to use tools that are not able to respect fundamental rights or to implement the parts of the law that are there in order to respect fundamental rights, then we are undermining the application of fundamental rights on the internet. And this is doubly concerning because there is the open question whether or not the Charter of Fundamental Rights or human rights in general can be enforced against private companies. So if we continue to go in this direction of delegating decision-making power and implementing power of our laws to private companies, we also need to have the conversation to what extent we can enforce our fundamental rights regimes against those private companies. And I think there are a lot of really interesting food for thought in this volume on whether this should be done, how this should be done, and how we can make sure that we have a rule of law-based and fundamental rights-based regulation of the internet. Thank you.
Thank you very much, Julia and David, and thank you very much for providing us a leg to the following part of the panel, which is the food for thought that is in the book. So I would like to ask the authors of the book to join us here. So we will switch. So we have Christoph Gartzka and David Erdős from University of Cambridge, Christina Hutzi-Orban from the University of Essex, Judith Herzog and Lodfred Mazou from the French Digital Council, Emily Laidlaw from the University of Calgary, Marian Fernandez-Perez from the European Digital Rights, Rolf Weber from University of Zurich, and last but not least, Natasha Tuzikov from York University. We have a very big set of panelists, so we will moderate from there, and I hope you will manage to keep your 3-4 minutes per person so that we can also have some debate at the end. So we start, sorry? We start with Emily with the order of the book, following the order of the book.
What's the order?
Yeah. We're checking.
Perfect.
Please, Emily, the floor is yours.
Oh, thank you. Hi, everyone. I'm Emily Laidlaw. What I'm going to do is just briefly kind of try to generate discussion, because I know everyone wants to have a discussion later on about these particular issues. And what I want to talk about is platform responsibility and human rights. So the general theme of the questions I've been asking myself are, what are the responsibilities of platforms for human rights standards? Or another way that I approach the question is, what exactly do we expect of them? So the work that I have done, and I talk about in the book, is that intersection of corporate social responsibility, regulation, and human rights. We're really in the early days of exploring a lot of these particular questions, yet at the same time I think we're at a critical juncture here where a lot of major social issues when it comes to online abuse, fake news, data, fill in the blank, whatever you want to say there, are all occurring in this kind of gray area between law and corporate social responsibility. Now, I've done quite a bit of work creating regulatory models, trying to conceptualize gatekeepers, but what I want to do with my brief few minutes is focus on some of the major issues I see going forward in this area of kind of law, CSR, and human rights. There's really 4 that I'm thinking about at the moment, and I don't by any means think this captures all of them. One is consider for a moment online abuse. If a company more narrowly defines freedom of expression than just sort of the base legal standard, and we see this often with the community standards on social media sites, is this a company being socially responsible, or is this censorship? Is this, a privatization of the human rights system, or is this just, living up to their human rights responsibilities? The uncomfortable reality is really that it's both, and it depends on context. But what we do need is, I think, a more open conversation going forward with companies of what exactly it means to kind of walk that particular line. The other issue is, what are the ways that we can use law or craft law to incentivize social responsibility? So I've looked at a lot of different things here. One is requiring that internet companies report annually on their human rights impact that we've seen in other areas of the law, these types of commitments. It's almost like good parenting, where you say, I'm not going to tell you what you have to do, I'm not going to be prescriptive that way, but I'm going to mandate that you report back to me what you've been doing. Co-regulatory models, some stronger governmental role perhaps, although that might make people uncomfortable as well. A larger role of education, research, and dispute resolution. And a lot of this raises issues of how do you harmonize intermediary liability rules, and can you do that? I think in a lot of ways the future of what we're seeing in this area is less about these kind of old school strategies of command and control regulation, and it's a lot more about systems of governance, both with legal and non-legal elements. Now, the last 2 points I want to make are to do with business and human rights, in particular, Ruggie's guiding principles. An enduring question that we haven't solved is really, what is the scope of the duty to respect human rights? Does this require respect for all interferences of human rights, including by private parties? My reading of it is that it does involve respect for all interferences of human rights, but there is a disconnect between, I know what my view is, and the approach taken by many platforms. So if my friend posts some intimate, embarrassing picture of me on social media, does a company have a duty to respect my privacy, separate from whatever is outlined in its community standards? Is there an obligation here or a social expectation to respect my privacy? Or are we just looking here at a duty that, that involves restrictions related to government interferences with rights? And this impacts the last question that I have, which is, and I will be quick about this here. My last question is really about the right to a remedy under the guiding principles. In general, that is an underdeveloped area in the guiding principles, but it's a particularly pressing problem when we're looking at platform governance. My main question is, how do you resolve disputes? So we've talked about a lot here. We've talked about issues of fake news. Is there a right to be heard? Should you have a right to appeal? How do you deal with algorithms and decision making? My more basic question is, what makes a good dispute resolution system? I have been doing other work recently for the Law Commission of Ontario about defamation reform, and basically went to the beginning and said, how do you resolve a dispute? We need to look at innovating really what the guiding principles and a right to remedy in human rights terms means when you also look at issues in the area of legal innovation and dispute resolution. And I wrapped up for you now, Nicolo. Thank you.
Thank you very much, Emily. Now on with Myran from EDRI.
Hi, thanks so much. So I'm here representing European Data Rights EDRI. We're an umbrella organization of 35 NGOs. We're based in Brussels, and our members are represented in Europe and across the globe. So on the one hand, we see a trend in Europe towards pushing companies to do more, as we've heard, to deal with several public policy objectives, with big companies taking the lead and becoming not only the police, but also the internet legislator, adjudicator, and judicial power. And that's what we call in EDRI privatized law enforcement. In addition, you have public authorities that are not taking a diligent or appropriate steps towards ensuring adequate framework that is respectful towards rights, the rule of law, and basic principles. And the Commission's communication on illegal content is an example of this. And then you also have newer approaches such as trusted flaggers or also internet referral units. On the other hand, however, there's some hope. I see that there's quite a good work and quite a lot of support in the international arena towards having a rights-based and diligent approach. We welcome the work done in the Council of Europe, intermediaries recommendations that are currently just a draft. We also welcome the work by David Kay. We also welcome the work done by MEPs such as Julia Reda and other MEPs that have written several times to the European Commission. And so you may be wondering, okay, so what's your take on all of this? So from a European data rights perspective, we think that what we need is a diligent, right-based, and comprehensive approach to this problem. So how do we do this? So first, we propose that we need an understanding and respect of a fundamental rights framework. For example, what does it mean for a public authority to need to respect the Charter of Fundamental Rights? And more specifically, what does it mean to have to respect to Article 52(1) of the Charter, which says that restrictions on fundamental rights need to be provided for by law, be necessary and proportionate. As you know, there's been a push for companies to take the lead and action on the basis of the terms of service and not based on democratically based laws. So that's the first step. And also we need to see, for example, whether there's any robust protection for due process, safeguards for removal of legal content, how is the right to remedy being implemented, so on and so forth. So that leads to the second point, which is learning from experience. We need to have an approach where we really address what has worked in the past, what has not worked, and what do we do about it. So the third point that we want to bring is building a flexible and effective approach to the issue. We think that regulation by algorithm is not the solution. Also, one fits all is not a solution. If we keep regulating the internet as if it was Google, it will become one. So we don't want to go forward into that direction. If we also keep regulating this area on content regulation on the basis of copyright holders' interest, we won't solve really the public policy objectives. So by removing content, the solution towards fighting, for example, against terrorism is not done. Quite the opposite. It's a very superficial action which does not determine whether the public objective is being achieved. And so, so in the paper, we go a step forward and say that we recommend in the European Union to have a directive on notice and action. We have seen with recent political developments that we are not there yet. So before we go into there, and then you see in the chapter that we wrote, my colleague Joe Magnamy and myself, that you know, we propose certain points that this directive can consider, including prevalent identification, also trying to map which stakeholders we're trying to make them to react and take responsibility, or are we just talking about the big companies or not, and many other aspects that you can find out in the chapter. With that, I leave it to the others.
Just to remind to be brief, please, is due mainly to the fact that this year our session has been slashed from 90 to 60 minutes. And by the way, I would like to urge you to write to the IGF Secretariat to ask why the MAG has decided to give only 60 minutes to a session made up of people that work the entire year to do some concrete outcome rather than 90 as we had the previous years. So you can write at igf@unog.ch and asking why the MAG has decided to reduce the session. Now we can go on, and we can have 10 extra minutes at the end as we started with a little bit of delay due to the queue at the entrance. So the next one will be Christoph. Or David, yeah, we're the one that we are co-authors.
David Erdos from the University of Cambridge. So Christoph and my paper focused on the right to be forgotten and search engines, which we've already heard quite a bit today. And I think it's fair to say that that is an issue which is generally seen as an EU issue, and even potentially an issue which is linked to just one idiosyncratic decision of the Court of Justice of the EU, namely Google Spain. And the purpose of our paper was to really question that understanding through comparing what is going on in the EU with 5 transnational, beyond the EU, data protection frameworks. So we looked at the broader Europe of the Council of Europe, the OECD, which bridges a number of different regions, the Asia-Pacific APEC framework, the ASEAN framework in Southeast Asia, and the ECOWAS framework in terms of what do they say about the right to be forgotten and search engines. And I think this question has topicality, not only because of the controversy of the decision, but also because this issue of territoriality is becoming key even in Europe itself as it looks to what is the reach of the Google Spain decision itself. It's an issue which is going to be decided again by the Court of Justice. Now, Christoph, my colleague, is going to go through the empirics and the implications of those empirics. What I want to do is very briefly clarify what we mean by the right to be forgotten and what is necessary for that to apply to search engines. So what we don't mean by the right to be forgotten is one specific legal right. Yes, the new General Data Protection Regulation does now have something badged as the right to be forgotten in that sense, but that's not even in the current EU data protection framework. Rather, the right to be forgotten is a broad concept, basically saying that individuals, if they're concerned about potential or actual damage, should have some ability to restrict access to even publish personal data about them, so long as there is no overriding legitimate interest to oppose that. So turning back to the EU, it was that concept which was seen to stand behind more specific aspects of the scheme, the right to erasure and the right to objection. Secondly, well, what is necessary for that to then apply to search engines? Well, fundamentally, it's necessary that they are considered to be controllers of data. And again, in the EU, that demands that they alone or jointly determine the purposes and means of processing. And the Court of Justice actually found that that was clearly the case. No one was forcing a search engine to collect data and use it in a particular way. But they also laid emphasis on what the purpose of EU data protection was about, protecting fundamental rights to privacy and related rights, which was severely impacted by the nature of modern technology and search on individuals' name across a vast range of different sources. There are myriad issues in this debate which we have absolutely no time to go into, and I don't mean to downplay them, but it's those two questions which also confront an analysis of transnational data protection regimes, which I'm now going to pass over to Christoph to explore.
Thanks, David. As earlier mentioned, we looked at 6 international data protection frameworks in total. And within those frameworks, we first looked for the presence of a specific post-publication right, which would enable the data subjects to stop processing which violates core data protection principles. Now, what we found was that 4 frameworks, that of the EU, Council of Europe, OECD, and ECOWAS, could be seen as directly containing such a right. Now, 2 frameworks, APEC and ASEAN, were found to only contain the right focused on removal of access to inaccurate personal data, as opposed to data violating wider data protection principles. However, APEC's instrument, to a large extent, replicates many data protection principles, and it also contains a requirement to provide a remedy when those principles are violated. Hence, the right we are looking for could be found in this indirect manner. This interpretation, however, is not possible within the bounds of the ASEAN framework. Now, secondly, we assist the instruments in search for the definition of a data controller, which could encompass search engines' nominative indexing of personal data. And what we found here was direct resemblance with the definition of the Data Protection Directive in cases of Council of Europe, APEC, as well as ASEAN, despite the lack of a standalone definition in the last instrument. Now, OECD and ECOWAS were a less direct match in this regard, and required us to look closer at the decision-making role of the data controller. To use OECD as example, we had to compare deciding on the means and purposes of processing, a term from the Data Protection Directive, with deciding on the contents of and use of personal data, a term from privacy guidelines. Now, in general, and that's an in general, search engines are not deciding over the contents of data, but over the use, yes, by deciding to collect, retrieve, store, and disclose information on their platform. Now, the CJU found that it does not matter whether the search engine chose to index personal data specifically or not. And if this was to be maintained, as we think it should, then such an entity as a search engine could be seen as a data controller within the OECD and ECOWAS instruments. To summarize our findings, counting the EU, 5 out of 6 international data protection frameworks we studied could, with the right interpretation, accommodate the key tenets of the Google Spain judgment, 4 of them in a clear and direct manner. Now, the one framework where it would not be possible is arguably a minor one, with only 10 member states from one region, and several of those member states are members of APEC anyway. What can be done with those findings? In our view, this means that the time is right for finding international consensus in this field. And the forum we'd propose for this to occur is the International Conference of Data Protection Privacy Commissioners. The way in which this body could act is by beginning work on a resolution focused purely on the right to be forgotten. Now, finding consensus on this matter on the international arena could not only enhance the presence of a right for those in legitimate need of it, but also prevent further legal fragmentation of cyberspace and a rise in unenforced court orders, such as the one seen in the recent trade secrets case of Acoustic. Thank you very much.
Thank you very much. So now we move on to Rolf Weber.
Thank you very much for the invitation to present a couple of thoughts. My introducing statement reads basically as follows. The growing discussions about data ownership, in particular in Europe, will not make a detour around the online platform markets with increased quantity and often also quality of data available on certain platforms. The assessment of ownership issues on platform markets becomes imperative, i.e. the question of who owns the data becomes crucial, since data is non-rivalrous and can be reused by the legal owner on the one side and the factual controller on the other side. And the question is, of course, to what extent is it possible that one is excluding the other. In my contribution, I looked at 4 regulatory challenges, namely collective ownership, data portability, access to data, and data sharing. And I quickly now address the 4 challenges. Collective ownership goes back to the already quite well-known concept of sharing the wealth strategy. We have come across that in connection with big data analytics. Such a concept premises on the data controllers to provide individuals with access to their data in a usable format. Equally, the individuals should be allowed to take advantage of applications in order to analyze their own data and to draw useful conclusions from it. The legal situation insofar is less clear. We do have certain instruments, for example, the cooperative, quite often used nowadays in the health environment. We have the form of joint ownership. However, the situation is by far less than clear, and further research and maybe also regulatory action in this direction will be needed. Second issue, data portability. The individual might obviously be interested to change the context of her data use from time to time. The right to data portability has its roots in the acknowledgement that control over data implies the possibility to move data at the request of the person from one online provider, from one platform to another. As we all know, data portability, as far as personal data is concerned, is now enshrined in Article 20 of the GDPR. I'm not going into the details of these discussions. However, non-personal data is not governed by the GDPR, even if data portability could also play a role in respect of machine-generated data. Insofar, we do have competition-oriented instruments that combat, for example, customer lock-in effects, which lead to increased switching costs or even to creation of market barriers for new providers. However, big disadvantage, and I may say so as an antitrust law professor, antitrust proceedings are usually lengthy and cost-intensive, meaning that in practice the antitrust instruments only play a limited role and can play only a limited role also in the future, as long as we do not have new alternative procedural elements such as ADR in competition law. Third challenge is access to data. Obviously, as far as personal data is concerned, we do have GDPR rules, which also obviously do not apply in the field of machine-generated data as long as they're not personal. In this context, we know now the most recent communication of the European Commission called Building a European Data Economy. It's about 11 months old, and it enshrines a couple of objectives, such as improving access to anonymous machine-generated data, facilitate incentives to sharing of such data, protect investments, avoid disclosure of confidential data, and minimize lock-in effects. We have to await what is going to happen in this context over the next couple of weeks or months. And finally, the fourth challenge, data sharing. Here, again, I would like to draw some thoughts from the EU communication, which has proposed a compulsory license system granting access to data that might facilitate the subsequent data sharing due to an increased availability of data. Compulsory license regime is obviously, again, an antitrust instrument, and this means that some principles of antitrust law will have to be taken into account. In particular, the discussions evolve around the so-called FRAND terms, the fair, reasonable, and non-discriminatory terms. This avenue would be a possible way to improve data sharing. However, again, procedural instruments should be introduced which would allow to implement data sharing ideas on short term and not only after a couple of years. Thank you very much.
Thank you, Rolf. So now we have seen the first two parts of the book that deal with human rights dimension, and the second part is about data governance. Now we switch to the third part of the book, which focuses on exploring the new roles of platforms. And we start with the presentation by the Conseil National Numérique. In particular, we have Lodfred Mazou and Judith Herzog. So your floor is yours.
Yes. So first of all, thank you for the invitation. So my name is Lodfred Mazou. I'm a policy officer at the French Digital Council. It's a public body whose mission is to produce digital policy recommendations for French government and MPs. And I'm presenting today with my colleague, Judith Herzog, on online platforms regulation. So without any further ado, I'm going to dive directly into the paper that we published in this book. So the whole idea is say, well, how do you hold online platforms accountable in the digital age? So we know that the rise of online platforms fundamentally challenge our regulatory framework in various ways, so I won't go that much in this topic. But the idea is like, how do you hold them accountable, and what are basically the policy response that we can bring about to address these issues. So basically, we introduced a principle of accountability in the law for Digital Republic in 2016 in France, which is basically the cornerstone of our framework to hold online platforms accountable. It's built on two main pillars. The first one is transparency. Basically, online platforms should be transparent about the use of data and basically their processing of data and activities toward end users and society at large. So this is the first main pillar. And the second one is basically auditability. So we shouldn't just be transparent about the activities, but they should give the means to check actually what they do with our own data. And that's the critical point here. So to basically extend on this, we think that we should develop these capabilities within regulatory agencies such as ours. So the question becomes, how do you develop first the technical capabilities to audit online platforms? So we need more engineering capabilities. We need lawyers and engineers to work more closely around these issues. And I'm going to let my colleague Judith finish on this. Yes.
What we detailed in our contribution. Okay, good, nice. Okay, so what we detailed in our contribution is the complementary need for evaluating platforms' accountability, platforms' level of openness towards public scrutiny. We proposed to introduce a broad principle of accountability, the French word being loyauté, that would be a complement going above a lot of other already existing rights, but which suffer from inefficiency, because we do not have, as Alfred already said, the capabilities to make them efficient, because we do not have the abilities to observe what is going on, to produce metrics. We do not have enough conventions to agree on what should be held as receivable metrics. So we propose that the principle under which you need to evaluate platforms, the first one should be, are they open to public scrutiny, and to publicly and have the ability to report to the public when platforms do not agree to be evaluated from the outside. This would mean, of course, regulators need to have the capabilities to access to platforms' data inside and to run tests from the outside, but also that we will need to build in the future more strong alliances between regulators, academics, and civil society to develop those capabilities. We already heard that kind of discourse when we around the world, government as a platform. So the idea would be to rely on the bottom-up information stream to detect bad practices and good practices also. But there is another reason for this need. It's not only about tactics. It's also about legitimacy, because we know that the capabilities to observe platforms are not evenly distributed in the society, and that in the future we can foresee that it will be a problem. For example, we know that we start to realize that personalization algorithms create some adversarial effects. They may tend to discriminate categories of the population, and we do not yet have the capabilities to foresee the next generation of people that will be discriminated. So we need to create the capabilities for the people and for the advocacy groups to access to the means to run tests from the outside of the platforms, to access to the means to make their voice being heard and make their points with data towards the regulators. Thank you.
Excellent. And also something to mention that in your book, you also, in the chapter, you propose an agency for the trust in a digital platform economy, which people might read further in the book, and you can ask perhaps questions later. But now we have to move on to the next speaker, who is Christina Husti-Holban. So.
Thank you very much. I work with a project called Human Rights, Big Data and Technology, housed at the University of Essex, and my contribution in this yearbook focuses on the human rights concerns related to content regulation by social media platforms when they are dealing with terrorist and violent extremist content. And this research is in reaction to host providers, including social media platforms, facing increasing pressure, including on part of states, to monitor and police content generated or disseminated by users. And the baseline for my analysis is that the standards used to decide how to deal with content, whether to permit it, whether to remove it or block it, and the procedures employed in this regard should be compliant with international human rights standards. And my analysis looks at whether and to what extent this is the case. When it comes to the standards used by social media platforms to decide on the legality or permissibility of content, they look in two main directions for guidance. On one hand, of course, to their terms of service, community standards, and their internal policies. And this is something that has been addressed at length at the IGF during other sessions, and issues about shortcomings when it comes to human rights compliance of terms of service have been highlighted. So I'd like to focus on the other direction that social media platforms have to look at, which is laws that are related to terrorism, counterterrorism, and violent extremism. And as we know, there is no universally agreed definition of terrorism or of violent extremism. So relevant definitions are found in a host of domestic laws, and domestic standards that are relevant to this area are extremely diverse. There has been sustained criticism of many domestic definitions of terrorism and violent extremism by international and regional human rights bodies, by NGOs, and by other stakeholders for being overly broad, for potentially encompassing lawful behavior and encroaching on freedom of expression. And under some of these definitions, almost any kind of use that deviate from the social norms accepted by the majority may be suppressed, and measures may target thought, belief, and opinion as opposed to actual conduct. When social media platforms implement these laws, they, of course, also contribute to the negative human rights impact of these laws and measures. And this potentially, of course, causes a tension between the business's obligation to comply with the domestic laws of the jurisdiction where they operate and their responsibility to respect human rights under the UN guiding principles on business and human rights. In addition, enforcing different standards in different jurisdictions comes with its own challenges and may result in over-censoring. And that brings us to the importance of the human rights compliance of procedures employed when assessing content. Assessing whether a certain post or certain kind of content is terrorist or violent extremist in nature generally requires a very sophisticated legal analysis. We, however, have very little information on how platforms make such determination, when they use artificial intelligence, when they use human expertise. The shortcomings of the use of artificial intelligence in this respect have also been highlighted. Algorithms are not foolproof, and that may lead to screening that is both over and under-inclusive. However, when it comes to the use of human expertise, that also is not without problems, because doing this kind of moderating right would require that social media platforms employ a highly trained and specialized workforce. And based on reports that we have seen, it seems that it's frequently low-paid and insufficiently trained moderators who end up being the de facto sentinels of freedom of expression online. And because of these shortcomings, it is very important that there is due process and adequate safeguards when it comes to content regulation and content moderation. That is something that is so far lacking, because users have limited options at their disposal to receive information about processes and to challenge decisions. Platforms, on the other hand, face their own challenges because they need to deal with a horrendous amount of content, they need to deal with onerous intermediary liability frameworks imposed on them, and they receive little to no help and guidance from public authorities in this respect. And considering all this, of course, in case of doubt, platforms are likely to err on the side of over-censoring, which leads to my conclusion, which is that while there is much to be said in favor of self-regulation and regulatory restraint on part of the state, when it comes to online platforms carrying out quasi-enforcement and quasi-adjudicative functions that are effectively taken out of the rule of law framework, states cannot just sit back and leave it to companies to regulate these processes. And the state obligation to protect human rights under international human rights covenants also includes an obligation to set up a proper framework and to create the conditions that make human rights compliant content moderation possible. And this is something where we still need a lot of work to do.
Thank you for this very interesting thoughts. And now we end up with Natasha Tuzikov with speaking about how digital platform may become revenue choke points, and then we'll open the floor for debate.
Thank you. Natasha Tuzikov, York University, Canada. My research focuses on platform regulation through informal means, through non-legally binding measures, and I just wanted to make 4 very quick points in relation to my chapter. And the first is the role of the state. So despite varying narratives of the state in retreat, the state in absence, voluntary industry-led regulation, in many cases, especially in informal regulation by platforms, the state takes a very strong direct role in shaping, calling for, demanding regulation by these platforms. The US government, the UK governments, the European Commission have all employed strategies of encouraging or coercing internet intermediaries to assume greater enforcement responsibilities, including through threats of legislation, and in the case of Google in the United States, threats and actual criminal investigation. The second point is that the goal of state pressure on intermediaries to act, to assume greater enforcement responsibility in the absence of legislation, is to institute what I call beyond compliance regulation. And this refers to pressure on internet intermediaries to exceed their legal responsibilities in the absence of legislation and in the absence of formal legal orders. And intermediaries really occupy this very uncertain regulatory environment. Legal disputes about the nature of their regulatory responsibilities, the degree to which they are responsible for third-party content on their platform, as my fellow speakers have talked about. And so we see intermediaries are very vulnerable to state pressure and more willing to adopt these self-regulatory measures in the absence of legal requirements to do so. But unlike legislation, this beyond compliance regulation is highly flexible, it's highly elastic, which means that states can continually pressure these companies to adopt more and more enforcement responsibilities in the absence of accountability and oversight mechanisms. The third point is that traditionally we've seen these big internet platforms, especially the large US-based ones, pressured by powerful states. So powerful states pushing these companies to act as regulators in the absence of legislation. And what my work points out too is what we're seeing is powerful multinational corporations, especially in the copyright industries, but also big trademark holders, the pharmaceutical firms, the big apparel firms, pushing these companies to act in the absence of legislation, formal legal orders to protect intellectual property rights. And this is because the protection of intellectual property rights is a key political and economic priority, especially for the United States government. And we're seeing the United States government pushing these companies to adopt greater enforcement responsibilities to protect intellectual property rights. And the fourth point is, why are these countries, these states pushing for beyond compliance enforcement? And certainly one reason that the United States is doing so is that it's able to embed its preferred standard, its preferred policies for the protection of intellectual property rights within these big internet platforms. So as these internet platforms set and enforce rules, they are acting in the way that the United States prefers in relation to intellectual property rights. And I think this raises a number of different questions, and what we're seeing is a pattern of global rule diffusion in which rules are set quite secretly among closed groups of corporate and political actors, largely in the global north, largely in the United States, some areas in Europe, and these are diffused globally. And I think they raise a lot of questions, and one question I just wanted to focus on or just wanted to raise was whose rules apply and where? And this raises a whole host of questions, and I think something that my fellow panelists talk about as well. Thank you.
Thank you, Natasha. And actually, your last point about copyright resonates a lot with one of the sections of our initial chapter that we called YouTube and I Regulate, that actually demonstrates that some of these platforms are becoming actually proxy for national, to extend national regulations, in this case, the US copyright regime globally. So that is actually a question of jurisdiction. So we can open the floor for a couple of questions. Do we have any remote questions? So I would also like to thank Lua Fergus, which is our remote moderator. Do we have questions from remote participants?
No, we don't have, but
Excellent.
we have people watching it. So
okay, well, wonderful.
Just
if they have questions, they can do very fastly, because I think we will have questions from the floor. So don't be shy. We will take 2. Please go ahead.
Hi, my name is Stefan Luca. I'm with the European University Institute. I sort of have a question related, so coming to the point that Ms. Tuzikov was making about how these strong corporations in areas of copyright and trademark put pressure on platforms for this kind of private regulation. I'm sort of wondering, in this sort of similar context of fake news, where does the pressure come from there? Because you don't really have like private actors that put kind of that, or you do have private media that put some pressure, but it's not the same kind of power.
We can take another question, and then we will leave the opportunity to the panelists to give final remarks, and obviously starting from Natasha. Okay, wonderful. So we can have panelists having final remarks, and we will finish almost on time.
The question of fake news is a very interesting one. Certainly, governments in Europe, I'm thinking the United Kingdom, in France especially, have asked platforms to look into this. And I think this raises the broader question of governments starting to turn to these platforms as de facto regulators, as go-to regulators. So whatever the issue of the day is, whether that's extremism, copyright infringement, fake news, interference in elections, they're simply turning to these platforms and saying, you have great algorithms, you have experienced engineers, do something. And I think that's very problematic, because the something is ill-defined. We don't know what they're doing, how they're doing it. The platforms have admitted that they're very ill-equipped to distinguish legality from illegality online. These are complex questions, as all of these chapters raise, and how these platforms undertake the regulation is very murky. And so it raises a whole host of questions, the idea of these platforms as de facto regulators.
Actually, if I can just add a remark, is also that in the nature of platforms, it is to maximize revenue and minimize costs. So the goal of the platform in implementing or designing a remedy will be the reduction of costs and the most effective, cost-effective remedy, not the most respectful of human rights. So they are the wrong stakeholder that should take this role and implement it. But I think there are other remarks there.
I'll just jump in with one comment because I think that my fellow panelists have captured a lot here. One comment is a lot of this, in some ways, is not new. That pressure from government on these intermediaries to regulate has been there from the beginning. If we look just back at issues of child pornography
through the ASO, I think it was a much broader community-wide issue and therefore very appropriate for a CCWG structure. But if you're talking specifically about a policy related to GTLDs, not related to CCTLDs, not related to IP addresses, then the PDP is the formal structure outlined in ICANN's bylaws where those policies are supposed to be developed. And I see Becky wants to weigh in here, but I'll just wrap up by saying there are some gray areas here, though, right? So I think one example that we're seeing today is this question about geographic names. So how do you classify or describe or define a geographic name? Today, it's a GTLD. It's not a CCTLD. There is no category today for anything else. So a geographic name is by default a generic top-level domain and therefore belongs in the GNSO and the PDP process. And of course, those processes are open to anybody that wants to contribute and participate. But there is a formal structure for the development of those policies. And those policies will eventually impact the contracts of the registries and registrars in the GTLD space. So I think it's a really interesting question. I am a strong supporter of CCWGs for that engagement where it is appropriate. But if it's very, very targeted on something in the GTLD space, then the GNSO PDP is, I think, where it belongs. So I know Becky wanted to weigh in, but Marcus, back to you.
Thank you, and my apology to those who are not members of the ICANN universe. We again throw around acronyms that mean nothing to the non-initiated. So
I apologize.
No, I started it. So the CCWG is a working group that involves everybody in the ICANN family, whereas a PDP is a policy development process that is uniquely in the GNSO. But I saw Brian, you asked for the floor. And
thank you.
Coming afterwards. And
thank you, Marcus. Grace and Larry.
Can you please introduce yourself?
Oh, I'm sorry. My name is Brian Beckham. I work across the street at WIPO, where I manage the domain name dispute resolution section. Grace and Larry mentioned kind of threshold concepts with respect to the multi-stakeholder model, which goes to sort of how far do we engage in consultation and how far do we defer to those consultations. ICANN's bylaws mandate that in its policy development processes, it should defer to experts. Lori mentioned that the UDRP, which is the policy under which we manage disputes that come to us, is going to be reviewed by ICANN. When this issue came up in the prelude to the new GTLD program, there was a decision taken to wait until the new GTLDs had launched. There was too much going on. This was the one stable mechanism we knew that worked. Let's leave well enough alone. But during that process, we approached a former board member and we engaged on the question of how do we bring our expertise in these policy discussions to bear. And we were told we should roll up our sleeves and join the working group. To me, that is at odds with the bylaws requirement that policy making should rely on expertise. And that gets back to a more core question in terms of what does multi-stakeholderism and what does consultation mean? Does it mean that we have to listen to everyone at the cost of listening to experts, or does it mean that there may be forks in the road where the kind of bottom-up community process comes to a different view than the experts would take, and where does that lead us?
Thank you. And Becky, and please introduce yourself.
My name is Becky Burr. I'm a member of the ICANN board. but I'm not speaking for the board. I was not on the board during the transition and was on the accountability working group, the cross-community working group. I want to tie a couple of themes together. So Larry made a point that was very interesting to me, which was the distinction between decision-making and consultation, and the critical nature of the sort of the multi-stakeholder model being about decision-making and about placing decision-making authority where you place it. That sort of plays into the expertise issue. But then there were also some comments about deadlines and urgency. And it's true that there wasn't an artificial deadline with respect to the transition, but there was a window of opportunity that could close, and in fact probably did. And the fact that there was a point at which a decision would be made, whether by us or for us, was a critical factor in providing proper incentives to create consensus. Absent that kind of a decision may get made without me, there are some pretty strong incentives, I think, to have kind of holdout and immovable object behavior. I think we've had some of that. So, so now I'm going to be provocative. I think that the PDP is actually provide some incentives to get out of holdout and immovable object behavior, because at some point a decision is going to get made, and if you're not at the table and if you're not participating in a way that contributes to developing consensus, well, that decision might get made without your input. And so I don't think that, CCWGs are good and PDPs are bad, or PDPs are good and CCWGs are bad. They serve very different functions, but a CCWG, in the absence of a window of opportunity that could close, and the proper incentives to reach consensus, strikes me as potentially not a good thing. So I think that the two things balance each other out and are very useful.
Thank you. And now we're running slowly out of time, but I would like to give the opportunity to all of our panelists to give a quick takeaway, but very quick, very brief. What is your takeaway from this session? Please, Ada, you start.
I think I'm even more than before driven to try to get this multi-stakeholder approach somewhere in politics. And I don't know how I'm going to do it, but I'm going to try it.
Great. Larry?
Well, I hope that the takeaway people have is that ICANN is a very unique animal in this system of multi-stakeholder processes. It's got its own unique idiosyncrasies and quirks and the silos that people referred to earlier. And in some respects, it's while I think it has provided the best demonstration of how well a multi-stakeholder process can work, it's not the model from which others should structure new approaches if that's going to happen. And I do think it's important to test out these ideas and see whether or not there's an independent basis on which we can find issues with the level of urgency. And Steve, you're absolutely right. If there's no urgency, people won't put in the time and effort. But how do you define an issue and find it in the right point in its life cycle that there is that level of urgency and a feeling that people coming together can actually make concrete progress towards solving a problem. And we're going to test that next year with this project at ISOC, and we'll find out whether people whether we can identify and convene on those sorts of issues and overcome a lot of the barriers to convening, which were mentioned, the logistics of finding a place to meet, to bringing in the internet connectivity, handling translation where you need it, providing financial assistance to ensure broad representation of viewpoints. These are all barriers that prevent people from just doing this on their own, but we're going to see if we can actually create this capability and find those issues to bring people together, and in doing so, hopefully provide some sense of legitimacy to the overall effort. But that's a different animal, and I think needs to be evaluated on its own merits and not be somehow characterized
brief,
according to ICANN. I'm sorry?
Very brief, I said. Matthew?
Yes, thanks. I think what this discussion has shown is that the multi-stakeholder model in ICANN works, and there's a lot to learn from it, but we also have to recognize that there are different multi-stakeholder approaches to different issues, and I think that we need to find those spaces where we can bring stakeholder expertise, maybe new policy areas, new issues that are pressing that we need to address. Thanks.
Keith?
Okay, thank you, Marcus. I think my takeaway is that you know, this ICANN experiment, a multi-stakeholder experiment, has shown that it has legs. I think it actually has shown success and is still evolving. I think there are clearly lessons to be taken from what we've experienced over the last 15 to 20 years in terms of multi-stakeholder engagement around the domain name system. And I definitely think there are opportunities to take this experience to inform other areas of policymaking and engagement that can benefit from our experience, even if it's not a direct copy of what we're doing. I think there are lessons to be taken. Thanks.
Thanks, Marcus. Thanks to all the panel and participants. I think the thing that I find interesting in the call to action I'd offer to you all is to think about what the obstructions are to using this model in other areas. For me, the key one I see is how difficult it is to create an environment where all of the participants in a debate have to come to a conclusion in the context of that debate. I really think, whether you call it a deadline or something else, that's what made the INA transition work. And so if you're going to multiply it, I see that as the key barrier. You might see different barriers. Thinking about those barriers and sharing them with people like Larry, who are trying to work on ways to make this model work, will help get a rounded perspective on the challenges that need to be overcome. So think about the areas that you work in and share that experience.
So I agree that multi-stakeholderism is still a work in progress, and I think we should, as far as possible, try to make it more and more meaningful, especially for stakeholders who are not participating adequately.
Aidan Fideline for the record. Echoing the comments that were previously made, multi-stakeholderism has worked at ICANN. If I was looking to take it to address another issue, for instance, I would look at the ICANN approach, but I would also be looking at why it is that nation states remove barriers to free trade in general. And I'll be looking at that neo-functionalism school of thought, the idea of a spillover effect, which is that the cost of not proceeding with further integration and abandoning the process becomes too large. So I'd be looking there as well to see if we might be able to identify those costs and apply them to different issues. Thanks.
Hello, Lori. The first thought that comes to mind is democracy is messy, and that's okay. And I think multi-stakeholderism, it's only, for ICANN, 2 decades old. I agree with Grace. It's still in its nascent forms. We really haven't seen its full potential. We've just seen a little slice. And that being said, I want to emphasize something that is near and dear to a lot of us in the community, and that is the capacity building that is required to make good digital citizens, to make people not just understand, but want to engage in multi-stakeholderism in a meaningful way. And I think that goes to a lot of the empowerment issues, particularly in countries like Grace's, where this idea of sort of digital citizenship and engagement may not have reached to the top of the priority pyramid. And how do we make that happen? Because until it becomes a priority, I don't see us making much progress, quite frankly.
Thank you. And here we are in the IGF, which is also a multi-stakeholder forum for policy dialogue, but it is not a decision-making body. But I've always been saying that it can shape the decisions that are taken elsewhere. And I think it stays important to engage in the IGF as well. And that allows me to end with a commercial. today is an open forum for ICANN in this very same room at 4:10, so please join the ICANN Open Forum. And with that, I ask you to join me in giving a big hand to all the panelists for an excellent panel. Thank you all, and thank you for your active participation.
Good morning, everyone. I think we'll get started. I'm Duncan Hollis. I'm a professor at Temple Law School, and I want to welcome you to our workshop on the Digital Geneva Convention for Cyberspace. I want to actually begin by thanking Microsoft personally for sponsoring me to attend this panel and to work with them on this idea, but more importantly, to thank them for the conversation that's been sparked by that idea of a Digital Geneva Convention. And despite the title of our workshop, I think our purpose today is not simply to debate the merits of the Digital Geneva Convention, or DGC as some are calling it, but to elaborate on the context which has given rise to this proposal, to situate it, that is, within the factual and normative circumstances. So specifically, I'm hoping our workshop today can address 4 discrete issue areas: the status quo, the normative discourse, the process question, and lessons from past precedents. So first, the status quo issue. And I'd actually like to do, if I may, a quick show of hands. For those of you out there, I'd like to see people raise their hands who feel that cybersecurity today is great, that things are going well, that we have adequate or effective cybersecurity, and the future looks bright. Can I see a show of hands? Okay. I think that proves the point, right? That we have a status quo where many, in fact, it looks like everyone in this room agrees that the current state of cybersecurity is, I sometimes say, the normalization of global insecurity. That the ICT environment is not secure, and we need to figure out a way to change things. Which then brings me to the normative issue. If we all agree that we need change and that the status quo is unacceptable, how do we do this? And for years now, the conversation has been around norms. Some of that's legal norms, clarifying how existing international law applies to cyberspace and cyber operations through the Tallinn Manual and things like that. And some of it is much more of a political normative process, like the group of governmental experts operating under the auspices of the UN's First Committee. Of course, as the recent failure of that GGE to reach a consensus report shows, our normative state of play also faces challenges, just like the status quo on the ground factually. In fact, I think we see 2 different sets of normative problems out there, the existential issues and what I call the interpretive issues. The existential issues is we don't know what the norms are. We don't agree on the existence of norms. And so we see, for example, recent debates about, is sovereignty a rule in cyberspace that states can violate by their cyber operations? Or should we have, as the Global Stability on Cyberspace, the Global Commission on the Stability of Cyberspace said, should we have a norm to protect the public core of the internet? We're trying to agree on what the rules or the norms are. And even where we have norms, say prohibiting the use of force through cyber means, we have interpretive problems. We've talked now for more than a decade, and we still haven't gotten any closer to agreement on what the interpretive or the proper interpretations of our norms are. And so that brings us to this idea that if the status quo is a mess, we need change. We can agree, even if we can agree on what the norms for those changes are, what's the process? What's the way forward? And it's here, for example, I think that the Digital Geneva Convention offers some answers, at least from Microsoft's perspective, this idea of a tech accord among ITCs, a treaty among states, and an attribution council. Of course, it's not the only possible way forward. And so one of the things I'm hoping we can discuss in this workshop is what are the alternatives to this idea and how do they compare? Finally, in discussing future processes, I think we almost inevitably encounter the past. We get calls for analogies to prior precedents, prior processes. Because the reality is cybersecurity is not our first global governance problem. And there are past successes from which we can draw lessons, including but certainly not limited to the Geneva Conventions themselves. And it may seem daunting, I think, to expect states to say, walk away from cyber operational capacities that they seem to have and be acquiring at a rapid rate. But we need to remember that we used to live in a world where states did things like sponsor slavery, plunder, gunboat diplomacy. And we're not in that world anymore because states endorse norms where they walked away from those things, and happily, for the most part, their practice has complied with their stated expectations. So consider, for example, the Geneva Convention's ancestor, the Paris Declaration of 1856. At the end of the Crimean War, 20 states said, you know what, we're done with privateers. We're no longer going to take private actors and who would otherwise be pirates and put them under the state's authority to go out and take things off of vessels, take private property and the like. Today, states have endorsed the Paris Declaration, and it's now firmly ensconced in international law and practice. So success is possible, even if the effort to get there is daunting. So I think in sum, we're hoping this workshop can begin a conversation inspired by, but not limited to, the proposal for a digital Geneva Convention, and to think about the current factual and normative context and ways forward. So how should we do this? I think we're fortunate to have a great group of participants. I'd like to begin, I'm going to ask kind of for 3 different stakeholder perspectives, beginning with Paul Nicholas to my immediate left, who's here representing Microsoft and can probably speak much better than I to the reasons for their proposal and its contents. I'm then going to ask Ben Hiller, who's with the OSCE, to offer some perspectives from an international organizational viewpoint. And then I'm going to ask Dr. Konstantinos Komaitis, who's the Director of Public Policy at the Internet Society, and, to offer some perspectives from ISOC's vantage point. I've asked each of them to make 5 minutes only interventions so that we can then have a broader panel discussion around some of the issues I've already introduced. And we'll be bringing in Yvette Issar, who's an academic researcher at the University of Geneva here in Switzerland, Maria Maciel, who's a digital policy senior researcher at the Diplo Foundation, and Alina Noor, who's the director of the Institute of Strategic International Studies in Malaysia. And then finally, and this is really important, I want to make sure that we leave 20 to 25 minutes for participation by both you in the room and our remote participants to ask questions, to comment on speaker positions, provide suggestions so that we can have a true dialogue. And I'd note a particular preference here. We had plans to have some government voices up on this dais through logistic challenges and the like. We don't. So any of you who want to speak, who are government affiliated, and you want to speak in a personal capacity, or if you want to express a governmental view, I think we'd certainly welcome that. And time permitting, I'll try and have the last 5 minutes sum up the discussion in ways forward. All right, let's begin. Paul, I can turn the mic over to you.
Thanks very much. This is my first Internet Governance Forum, and I want to thank you for the ability to participate in this sort of rich exchange of ideas and perspectives. The multi-stakeholder community of people in this room and around the world